So good morning, everybody. I see a lot of familiar faces. Most of you know me. I'm Rachel Brockle, the Director of Litigation here at Golden Gate University. And today we have a very interesting and very relevant topic for you for this event on police misconduct cases. And if you've ever thought about, what it's like to have those kind of cases where the officer, for example, in George Floyd had to be defended, or victims are suing police departments or police officers, for the loss of someone or for police brutality. This is the type of event where you might learn a little bit about both sides of the aisle, and you can get information that you might not get elsewhere. So we're excited to have Shawn Barnett here. He is a GGU graduate. And so that you can learn a little bit more about him, we have Chandni. She's one of our students here. She's in the intro to litigation, and she's going to be doing STEP this summer. She's going to read Shawn's bio, and then we'll go from there. So Chandni, I'll let you take it away.
Good afternoon, everyone. Shawn Barnett graduated with honors from Golden Gate University School of Law in 2013. He completed the STEP program while in law school and competed in 4 national mock trial competitions, earning an award for the best direction examination at the 2013 National Criminal Justice Trial Competition. He was a law review managing editor and received 3 specialization certificates in the areas of litigation, criminal law, and intellectual property. Shawn also receives his LLM in trial and appellate advocacy in 2014 from Loyola University Chicago School of Law. After graduating from law school, Shawn spent 5 years working as a litigation attorney for the City of Chicago, Department of Law, Federal Civil Rights Litigation Division, where he defended the city and police officers from civil rights violation claims. Shawn was involved in nearly 100 federal civil rights cases, defending municipal employees. During this time, not only did he take numerous trials to jury verdict, but he was involved with some of the most complex and high exposure cases involving law enforcement officers. He currently works at Hale in Monaco as an associate attorney where he represents victims of police abuse. Since entering private practice, Shawn has concentrated on civil rights and tort litigation in both state and federal courts, with the focus on police-involved shooting incidents, reversed wrongful conviction litigation, and general allegations of police misconduct. Determined to be a strong advocate for his client, he meticulously reviews the facts of each case, analyzes all legal options available, and litigates each case as if it will proceed to a jury trial. This dedication stems from Shawn's time in the U.S. Air Force, where he was instilled with a fundamental belief of achieving excellence no matter the task. Not only did this principle serve Shawn well in his time with the military and during law school, but it has continued through his legal career to the benefit of his clients. In his free time, Shawn enjoys reading, baseball, and skydiving. We are excited to have Shawn Barnett here with us today to share his experience in police misconduct cases. Thank you for being here.
And real quick, Shawn, just before you get going, just for the audience, if you can hold your questions till the end, we'll have a question and answer session. And then also we'll have a raffle at the end for some interesting prizes. So hang tight. And Shawn, I'm going to let you have the floor now. Thank you.
Thank you, Rachel. Yes, as she said, I am an attorney here in Chicago, and I've represented both police officers and misconduct cases. And now I primarily represent victims of police abuse, although my firm does do defense work with the City of Chicago, where we represent police officers and the city in more complex cases, such as the reverse conviction cases and high-profile police-involved shootings. And so what I'm going to do is I'm going to discuss a little bit of insights and the best practices that I have found through my 8.5 years of representing clients in police misconduct cases. So I'm going to give you both the insight on how to represent a victim of police misconduct and also how you represent police officers who have been wrongfully accused of misconduct, or rightfully, as I will go through it. So I have a slideshow that I'm going to just kind of use as my general prompt. Let's see here. All right, is that working? Can everyone see that? Okay, great. So this is just the cover page, and I'm going to show you the slide. I'm going to talk a little bit and give you some insights and everything like that. So what is a police misconduct case? And there are, really two types of things that you think about that. You have the more familiar type, which is under federal law, under the Civil Rights Statute of 42 U.S. Code, Section 1983. And I have the text of the law up there. But in short, what a Section 1983 claim is you are suing a state actor for deprivations of your constitutional rights under the 1st, 4th, 5th, 14th Amendment, whatever amendment you so choose. And so it's a private civil cause of action against state actors. And then but you also have state tort claims: battery, false imprisonment, assault, intentional infliction of emotional distress, malicious prosecution. And those are state common law tort claims. And you can actually bring any type of them against municipalities or public employees. Now, if you are thinking about going into and representing either police accused of misconduct or people who have been victims of police misconduct, pay attention to the statute of limitations, because for the federal claims, Section 1983 does not have an actual statute of limitations in the statute itself. It borrows from personal injury litigation, and in California, that's 2 years. Now, if you're thinking about bringing a state claim, know that the California Tort Claims Act, which I've added up there, General Code 910 to 913.2, it provides a notice requirement that you actually have to provide notice to certain entities within 6 months of the injury for you to be able to bring a state law claim against a state actor. So make sure that you're aware of that. There could also be some type of tort limitation or tort cap that prevents you from recovering above a certain amount for state claims. Now, that is only for state claims. Any state tort cap, it cannot be applied to a Section 1983 lawsuit. So that's something to keep in mind if you are thinking or debating what type of claim to bring. So here's a question here's two questions actually that I get asked quite a bit. Why should you represent victims of police abuse? And it's a trickier question than you might think, because a lot of the people whom I represent who have been injured by police, they are not always people who have had no other interactions with the law enforcement. Many of the people who I have represented have criminal histories, have served time in prison. And so I get asked, why do you want to represent those people? And the simple fact is, one, I went to law school because I wanted to represent victims of abuse. And two, I think that it doesn't matter if the person is good or bad. The Civil Rights Act applies evenly to everybody. And when we start letting police officers or government officials, start to erode those rights, then eventually those rights get taken from everybody. But why should you represent police officers accused of misconduct? And this is something that I struggled with a little bit when I first got out of law school, because working for the city of Chicago in the Civil Rights Division, defending officers, wasn't always where I thought I was going to be when I went to law school. I'm pretty left-wing, and I never thought about, representing police officers, especially those who have been accused of misconduct. And after getting the job and working with police officers, I came to the realization that most police officers, if not nearly every one of them, is just out there trying to do their job. You know, they don't wake up in the morning and think, oh, well, I'm going to go beat up some people today, or I'm going to go and frame someone today. The vast majority of the police officers that I have represented and that I have met in my career don't intentionally do anything wrong. They might make mistakes, but they're human. And a lot of them get wrongly sued because anyone can file a lawsuit. All you need is a piece of paper and a stamp to mail it to the courthouse. And so honest, hardworking police officers shouldn't be dragged into court on every occasion by anyone who wants to sue them. Because a lot of the lawsuits that I defended police officers in were, you know, filed by vengeful arrestees. They thought because they were arrested and they did not agree with the criminal charges, let's just say, that they could just turn around and sue the police and get a quick settlement. And every officer in that situation needs a strong advocate. And so if you're thinking about, you know, whether or not you should represent police officers accused of misconduct, just think of that and keep that in mind, because like I said, anyone can file a lawsuit, but any police officer needs a strong advocate. So right now I'm going to go through some insight onto bringing a civil rights claim on behalf of a plaintiff. And the first thing you need to realize is who can be a party. Now, it's not only the person that is injured by the police. For example, in an excessive force case, it would obviously be the person who was physically injured by the police. But if there are minors involved, or if the person is deceased, then it becomes a little bit trickier, because a minor needs a guardian or next friend. And if you're representing the family of someone who was killed by police, then you would actually need to have a court-appointed administrator of the estate. So, you know, you need to make sure that you know a good probate attorney if you decide you want to represent families of you know, people injured by the police, and a good family law attorney who has the insight onto what is required to disperse funds for settlements involving minors. It's a whole area of the law that I did not have any idea about when I first started representing plaintiffs. So make sure that you keep in touch with people that you go to law school with, because they'll be able to assist you in these types of situations. And if you have multiple injured parties, do you file multiple lawsuits or just one? Now, that's something that you have to really consider, because it might be easier to just file one lawsuit with 4 or 5 different plaintiffs. But it might also be beneficial to file multiple lawsuits. For example, here in Chicago, the City of Chicago Legal Department has the in-house authority to settle any lawsuit for less than $100,000. So if you file one lawsuit with 4 victims, the City of Chicago can only has the in-house authority to pay $100,000 for that entire case. But if you file 4 different lawsuits, they could pay $80,000 on one, $70,000 on the other, $60,000 on the third, something along those lines. So if this is an area of law that you want to get into, make sure you know the authority of the municipality's in-house legal counsel. Also, one thing that I've had to deal with when I first started representing people of victims of police abuse is you need to make sure that you clearly explain the consequences of bringing a lawsuit. What do I mean by that? If someone is currently facing criminal charges and they are thinking about filing a lawsuit claiming that, they didn't think that there was probable cause supporting their arrest, or they felt like that the officer used excessive force in affecting the arrest, explain to them that yes, you can file a lawsuit, but it could also affect their criminal prosecution, because the officers, if they're sued, they might try to push the prosecuting attorney to continue prosecuting the case or to not strike a deal. Now, it's not exactly, appropriate for that to happen, but it does happen all the time. No officer wants someone they've arrested to get a deal if that person is also suing that officer. There's also financial consequences if a person brings a lawsuit and loses, and you need to be upfront with your potential clients right off the bat, because in American courts, usually you don't have to pay for attorney's fees, but the prevailing party is entitled to costs. So for example, if you bring a lawsuit and you file it and you litigate it and you lose, then the defense can seek costs from your client, which could potentially be in the thousands of dollars range for deposition costs, filing fees, subpoenas, things of that nature. So you need to make sure that your clients are aware of that before you file the lawsuit. Now, how do you go about investigating claims? Now, you have to do your due diligence before you file any lawsuit. And the way you can do that when you're representing a victim of police misconduct is you want to get any documents or videos that they have or that they are aware of. And this day and age, it's almost certainly going to be the case where there was some type of video or photo of the incident. If it's an excessive force case, right off the bat, you should ask them for a medical release, which will allow you to get their medical records, to compare the medical records to what the potential client is saying, because you need to make sure that there's no contradictions in there. For example, if they tell you that the officer smacked them over the head with an asp, and then you get their medical records and they tell the doctor that, oh, they slipped and fell as they were running from the police or something along those lines, well, that's an ambiguity that you need to confront right up front. If the case involves some type of criminal prosecution, reach out to the criminal defense attorney. Now make sure your client calls them and lets them know so they will speak with you. But that's a good wealth of information. And if there's any other witnesses, make sure to reach out to them. Now, if you're bringing a lawsuit or you're investigating a claim of police misconduct, you can always send a Freedom of Information Act request to the municipality, and they should have to give you those documents within a certain number of days. Here in Illinois, it's 5 business days. I think in California, it's about the same, and then they can ask for some exemptions and an extension of time, but eventually they will have to give you the documents. And that's something that you absolutely have to do before you file any claim against a law enforcement officer, because you don't want to be blindsided by something in a police report that you haven't seen. Check social media for posts. That is a wealth of information, particularly if it is a high profile incident, and know your case law so you know what claims to bring. Because as I'm going to talk about what to do when you're a defense attorney, a motion to dismiss right off the bat is almost a mandatory filing that you're going to have to do. So let's say you've spoken to your client, you've decided you're taking their case, you've gotten the reports, the medical records and everything. So where do you choose to file? Well, as I was saying earlier, you can file in a federal court under Section 1983, or you can file in state court under common law torts. And there are benefits, there's pros and cons for each. So for example, in federal court, 42 US Code section 1988 is the fee shifting statute. And you remember when I said earlier that usually you don't have to pay for attorney's fees? Well, under this statute, the defense does. If you file a lawsuit under section 1983 in federal court and you prevail and your client is awarded more than just nominal damages, section 1988 mandates that the prevailing party is entitled to all of their attorney's fees. Now, this statute allows traditionally underrepresented individuals to be able to obtain top-notch legal counsel, because no legal counsel, well, let me not say no, very few legal attorneys or very few law firms are going to represent somebody for potentially years if the outcome is going to be $5,000 and it's just the principle of it. The Congress wanted to incentivize attorneys to take these types of cases and to represent victims of abuse and to defend the constitutional rights of civilians. So section 1988 provides that those attorneys will receive reasonable attorney's fees for the work if they prevail. I have seen it where this statute has been used abusively. I'm thinking of one situation where a set of attorneys represented a victim of police abuse for several years, went to trial and got a verdict of $17,000. They then filed a petition for attorney's fees of $280,000. Eventually that was whittled down, but the attorneys, through this fee shifting statute of section 1988, ended up getting close to $200,000 in attorney's fees for a $17,000 verdict. So, you know, it's a powerful tool for representing, you know, for justifying bringing a civil rights claim all the way to trial, but it can be used abusively, like I said. And so that is a pro for filing a case in federal court. But a con is that the federal jurisdiction is huge. There's a map on here that shows the Northern District of California, which is where San Francisco is. So instead of just getting a veneer of people who live in San Francisco, you could get people from Lake County or Napa or Sonoma, which could be a lot more conservative than just a jury of people just from, you know, from San Francisco. And out here in Illinois, where I practice, in Cook County is where Chicago is, which is a very, very liberal and very, very diverse veneer. But if I file a federal claim, then I'm getting the suburbs. I'm getting more rural counties where those types of individuals might be more inclined to believe police officers just at face value, rather than being a little bit more skeptical of every witness. And that's why you could also decide to just bring a claim in state court, which you have a veneer made up of local residents, but you don't get the benefits of the attorney's fees. So that's a decision that you need to make by knowing your jury veneer and your jury pool. So you draft the civil complaint, you decide you want to file it, and you file it. Now what do you do? Now you can sue anyone who you want, but you have to make sure that you serve everybody. Individual officers can almost always be served through the law enforcement agency that they work with. You can send a waiver of service to the for example, a sheriff's office, legal department, and usually they will accept that on behalf of the officers, because they don't want you to have to go and personally serve each police officer at their home address. You also have to make sure that if you bring a claim against the city or the county, that you serve the city or county clerks. Now, Federal Rule 4M allows for 90 days. So you have to make sure that everyone is served or has signed off on a waiver of service within that time period. And if you can't do it, then you need to file a motion for an extension with the court to make sure that you do serve anybody who needs it. All right. Now let's say you decide to go the other way and you work for a firm that is hired to represent municipalities and police officers in civil rights litigation. So what do you do if you have a client comes in and say, I've been sued? Well, you identify if your officers are properly named as defendants. Now, Section 1983 requires that every defendant be personally involved in the alleged constitutional deprivation, or that they were a supervisor in charge who was closely connected to the injury. Know that a municipality or county can only be a direct defendant under two circumstances. One, if it's a state claim, they can be named under respondeat superior, or the only way a municipality can be held a direct defendant in a federal Section 1983 lawsuit is something called a Monell policy claim. And that is a whole different set of standards. It's a very complex area of the law where you have the plaintiff not only has to plead and prove that there was a widespread or direct policy that was problematic, but that policy was the moving force behind causing the constitutional injury. And you have some firms who specialize just in those types of claims because they are so complex and they require so much more discovery and expert witnesses and depositions that those types of claims can cause a case to drag on for years. Check to see if any of the claims are subject to a Rule 12b6 motion to dismiss. That is one of the first things that you need to do if you represent police officers, is to see which claims or which defendants you can get kicked out. And almost always, you will want to remove a state case to federal court. Like I said, here in Chicago, if I were to file a civil rights lawsuit in Cook County, which is where Chicago is located, the ink might not even be dry before the defense would remove it to federal court, because you have a more diverse, politically veneer, let's just say that, in federal court, because you have those more rural counties who, like I said, tend to be more supportive of law enforcement than larger cities. And how do you investigate claims as a defense attorney when you represent police officers? Well, you gather all of the police reports for this incident. One thing that I always do is I gather all police reports for the plaintiff from any arrest, because many times the person suing the police will have gotten arrested in the past and said, I'm going to sue, or something along those lines. Check the criminal docket for any convictions and the civil docket for the plaintiff's litigation history. Many times I've seen situations where an individual will file a pro se lawsuit against the officers, get it dismissed, then retain an attorney, and that attorney will file a lawsuit on the exact same thing, not knowing that the plaintiff had previously filed a lawsuit. And so, res judicata bars that. So make sure you do your due diligence and you check to see if this plaintiff is a frequent litigator or vexatious litigator. If you've been hired to defend police officers in a civil rights lawsuit, more often than not, any non-defendant officers who are on scene will be more willing to talk with you and explain what they saw than if you represent the victim of police abuse. So take advantage of that. Speak to any non-defendant officers and other witnesses who are on scene. And this last one is something that I added in here because of something that happened to me when I was an attorney representing police officers. and that is get the entire criminal file and transcripts. And I had a case where an individual was saying that the officers fabricated an inculpatory statement that he made where he confessed to ownership of a gun. And he said that the officers fabricated that. He spent 4 years in jail awaiting charges, and then the charges were dismissed. So that's potentially a huge claim because the individual spent 4 years in jail awaiting these charges, and he's claiming that the only evidence of it was a fabricated statement. Well, I went and got all of the criminal transcripts for every proceeding. And I was really surprised to see during a motion to suppress hearing, he got on the stand and said, yes, he made that statement, but it was because he felt that he was in custody and he was not Mirandized. So I showed that to the attorney representing that plaintiff, and he immediately dismissed the case because obviously his client was not truthful with him, and there was objective evidence that the plaintiff's claims were fraudulent. So the criminal trial and the transcripts can be a wealth of information. So take advantage of that. Now, here are some general tips on conducting discovery that I've found have been useful during my practice. Now, when you're representing plaintiffs, you want to come off strong. You want to have strong initial witness disclosures where you identify all of the medical providers, all of the witnesses, and you send specific interrogatories and requests for production. Now, I'm not sure how many of you have taken civil procedure or you know what an interrogatory is, but it's a written question that the other side has to answer under oath. So you can, if you're representing, like say, a plaintiff and you're claiming that he was arrested without probable cause, send an interrogatory to the officers saying, identify each and every fact that you assert established probable cause for my client's arrest. Now, while the attorneys for the defendant are going to assist them in writing these, they are going to have to answer. So it'll at least crystallize in your mind everything that they're saying justified the arrest. Don't forget about Rule 36, which is a request for admission. You can do a lot of cutting through the BS if you do use this discovery tool properly. You can authenticate and verify that documents are what they purport to be. So you don't have to do depositions on that. You don't have to lay foundation for those documents. If there was not a warrant for your client's arrest, instead of having to spend time during a deposition asking about warrants, you can send a request for admission, admit that the officers didn't have a warrant for my client's arrest, or admit that they didn't have a search warrant. So those are a very powerful tool. And if you aren't sure about something or about a policy or procedure, use Rule 30b-6, which is a deposition of the corporate representative with the most knowledge about a certain subject. For example, if you want to know what an agency's policy is as it relates to processing someone through booking who makes a suicidal statement, then you would send a 30b-6 witness for the witness most knowledgeable as to their policy, rather than trying to piecemeal it through regular officers or booking officers or sergeant. You get the corporate representative, the person who the defense will say, yes, this is the person who will be able to speak on behalf of, like, say, the jail on this subject. And as someone who is bringing a lawsuit against law enforcement and who's going to have to prove this in court, you want to make sure that you get every single civilian witness that you can to sit for a deposition. Now, I've had situations where plaintiff's counsel have said that they are representing these people, these civilian witnesses. I never go that far because I don't want to be ever put in that situation, but I will facilitate getting civilian witnesses to sit for depositions, because the civilian witnesses, if I've disclosed them, they're going to be good for my side. And so I want to make sure that they sit for a deposition. Because if they sit for a deposition, then it is almost a certainty that their testimony is going to be heard in front of a jury. So any civilian witness that you can present for a deposition and get them deposed, do it. Now, what about when you represent police officers? Well, it's very different. You want to make sure that your initial disclosures, you identify all of the officers who were on scene, because it will require the plaintiff to have to spend money and time in identifying certain officers and deposing every officer that you're saying is a witness. A wealth of information is jail and prison phone calls. That's something that we're just starting to realize just how vital they are, because even though witnesses are told on a jail call that is being recorded, many times they make admissions that they later try to retract during depositions. And it's a great insight into the witnesses or the plaintiff's personality and their character by listening to those phone calls. Make sure to list any foundational witnesses you want. If you're going to try to get in certified convictions of the plaintiff or other witnesses, identify that the clerk of the court would be able to be called to lay foundations. If you have a complaint that's very vague and it just says the officers struck the plaintiff 17 times or something like that, send specific interrogatories asking what each officer is alleged to have done, and follow up on that, because many times the plaintiff's attorneys will send a vague and ambiguous response to an interrogatory. Don't let them get away with it. If they're bringing these allegations and these accusations against officers, the officers are entitled to know exactly what they're being accused of. So send specific interrogatories to cover those allegations. Don't forget about co-defendants and co-arrestees. If someone was arrested and they're claiming that the arrest was false, if they were arrested with someone else, get those files as well. And here's a good rule of thumb that I do in every case. When I send out my initial written discovery requests, I also send out a notice of deposition of the plaintiff. I want the plaintiff to have to sit for a deposition first, because I want to ask them all about their accusations first. I don't want them to be able to sit through the depositions of all of the officers. And at that point, after hearing all of those depositions and all that testimony, then being required to come out and testify. So you want to get your notice of deposition out first, because courts will generally compel the plaintiff to sit first for the deposition. Now, presenting your client for a deposition, and this is something that is very, very different along with general discovery. For a plaintiff, you can't win your case through the plaintiff's deposition. You can only lose it. So you want to make sure that any answers they have are short and to the point, and you do not want to elaborate on damages or anything like that. You want to save that for trial. You want the defense to hear it for the first time in front of a jury, so they won't be prepared for it. Now, when you represent officers in depositions, it's very different, because you want to use each officer deposition to affirmatively lay out the entire investigation and the entire situation. Because based on the case law, you can win your client. You can win the case with your client's deposition if you represent a defendant officer. For example, if a plaintiff is claiming that they were falsely arrested, which was without probable cause, and that they were prosecuted without probable cause, then you want to ask each officer to set forth the factors that they considered before they made the arrest and got charges. You want to affirmatively ask questions of your clients to get a clear record. Now, when the plaintiff's attorney is asking your client about the entire investigation and everything, the questions could be confusing. They could be all over the place. you want to make sure that at your time, at the end of the deposition, you affirmatively, in a very clear and concise manner, set out what you want to set out with your client. Did you consider for example, did you consider the statement of this witness? Yes, I did. What did that witness say? And then your officer can explain it. Okay, did you take into consideration this witness? Yes. How? Why? So that way, when you file for summary judgment, you will be able to cite that to that point in the transcript, and the judge, when they read it, will be presented with a clear and crisp record. Because that's what you're doing as a defense attorney. You are setting up your case for summary judgment. What is summary judgment? And this is something I didn't really know about in law school. For the federal rules, it's a motion for a judgment in your favor. And it'll be granted if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to a judgment as a matter of law. Now, you file these typically after the conclusion of either fact or expert discovery, depending on the schedule that the court sets up. For a plaintiff, it is incredibly rare that you will ever be able to move for summary judgment. Typically, the only times you're going to be able to move for it is if there's some type of video evidence, because most jurisdictions have found that any testimony that is contradicted by the video evidence must be disregarded. The video speaks for itself. But as a plaintiff attorney bringing a civil rights lawsuit, it's an almost certainty that you're going to be responding to a summary judgment motion. And you need to be prepared, because federal summary judgment motions are complex and they are time consuming, and they are not just something you can throw together a response to in a couple of hours. You want to block off probably a week to respond to one of them if it's well done. But what about as a defense attorney when you're representing an officer? Like I said, all of your discovery has been leading to a dispositive motion. And know the local rules, because sometimes their jurisdiction require a meet and confer before you file for summary judgment. You have to send the opposing counsel a letter saying, hey, you know, here's the claims you're bringing. These claims are entitled to summary judgment. Please just dismiss them. And know the case law and affirmatively put evidence in the record during the deposition for each of the elements. For example, a malicious prosecution claim, and I'm just going to take this one because it's fairly easy. The plaintiff has to prove that the defendant caused the prosecution, that there was no probable cause, that there was malice, and that the criminal charges were dismissed in the plaintiff's favor in a manner indicative of innocence. So if there was probable cause, you want to put forth as much evidence of probable cause as possible. If one of the officers was not involved in the filing of the criminal charges, well, you want to affirmatively put on the record that that officer did not have any involvement in the criminal proceedings. If the criminal prosecution was dismissed because of a plea deal, usually that bars a malicious prosecution claim. So make sure to affirmatively put in the record that the case was not dismissed because the client was innocent. It was because it pled guilty to a lesser charge or an alternative charge. Because as a defense attorney representing police officers, you have a huge arrow in your quiver, and that is qualified immunity. Now, there has been a lot of talk in the press recently about ending qualified immunity. And from what I see, most of the politicians or the legislative members or the activists don't really understand what qualified immunity is. So I'm going to kind of explain it quickly. It's a judicially created doctrine to shield state actors from civil liability. And when a defendant asserts qualified immunity, the plaintiff has to not only prove that one, constitutional right was violated, and two, that the right was clearly established at the time of the violation. And this is the plaintiff's burden to prove this. And if they can't, then typically a court will grant summary judgment in the defendant officer's favor. And it's a pretty high burden because the plaintiff has to come forward with really persuasive case law that the right that they are asserting was clearly established, which requires not an exact fact by fact identical situation in which a court previously found that a constitutional right was violated, but pretty close. And the Supreme Court has been making it more and more difficult for plaintiffs' attorneys and for plaintiffs to get over the qualified immunity because they are becoming more and more strict in the types of cases that they will consider analogous. Why does it exist? And these are my own personal beliefs on the situation, but qualified immunity exists because the courts did not want to punish state actors for doing something that they didn't know was wrong at the time. For example, let's say that the Supreme Court tomorrow comes out with a law, with a precedent that says we want to protect juveniles, and so we are finding that any officer questioning of juveniles without the presence of a parent or guardian is a violation of that youth's Fifth or Sixth Amendment rights. So it would be the Fifth Amendment. So from this day forward, any questioning of a juvenile that is done outside of the presence of their parents or guardian is a violation of the Fifth Amendment. And any introduction of any statement made under those circumstances is a violation of their due process rights. Let's say tomorrow the Supreme Court does that. If they won't, but let's say they do for this hypothetical. Well, does that mean that any officer, as of any time before that, questioned an individual or juvenile outside of the presence of their jury or outside of the presence of their parent or guardian, technically, as of the case law as it stands now, violated that person's civil rights? But should they be held liable for something that they didn't know was wrong? So that's why qualified immunity exists, because you have to give fair warning to the officer that what they're doing is wrong before they can be held liable. That's why it exists. But the case law has indicated that it has gone far beyond that. Because by requiring a nearly factually identical situation to have occurred before you can hold officers liable means that a plaintiff who was a victim of police misconduct and who did have their rights violated is now precluded from seeking any civil remedy or any financial compensation for the violation of their right. And that's just not fair, because the victim didn't do anything wrong. They were the ones who were injured, and now the Supreme Court and this doctrine has prevented them from using Section 1983 to address the deprivations of their rights. But until this doctrine is abolished or stricken down by statute, it is probably the most powerful tool that an officer representing police or that an attorney representing police officer has at their disposal. So make sure that you assert the qualified immunity doctrine as an affirmative defense in your answer to the complaint. And keep it in mind when you are litigating the case, because you need to know the case law and you need to be able to set your case up to be able to file for summary judgment on this doctrine. Now, here's something that they don't teach in law school. How to tell a client they're going to lose. Because you might take a case of, a potential client, and you might think that they have the best case in the world. They think they have the best case in the world. And you're going through discovery and you're doing depositions and you're pumped. And then you realize through some of the depositions that you're going to lose. either for qualified immunity purposes or because there was a witness changes their story and now is testifying that they did see your client commit the criminal act. So how do you tell your client that they're going to lose? Well, this is a conversation that you needed to have set the foundation for during your initial client meetings. And you want to explain to your client that these are difficult cases to prove. And as you've been going through discovery, you think that the way that the case law is, that there's a good chance that the court is going to grant summary judgment in favor of the officers. Now, many clients won't want to hear that, but you need to make sure that you document your communications with your clients so you are keeping them informed of the fact that you are not like you are almost certainly going to lose on summary judgment. Now, how do you tell a police officer that you're going to lose or that they violated someone's civil rights? That is a very difficult conversation that you have to have, but it's one that you owe it to your client and you owe it to society to be able to have with your officer client to make sure that they don't do the same thing in the future. And you want to tell that to them gently, because no officer wants to be told that they violated someone's civil rights. But you do have to tell them, and you have to explain to them why, what they did wrong, and what they need to do in the future. Don't just blow it off. Don't just tell them that, hey, we're going to settle this case for whatever reason. You actually owe it to your client to tell them what they did wrong so they don't do it in the future. I'm getting close to my time, so I'm going to go through this more quickly. Some trial basics. One of the most important things that nobody wants to do, but that you should do when you're preparing for trial, and that is take the lead in crafting jury instructions. Because the jury instructions are the law that the jury is going to be informed of when they go to deliberate. If you take the lead in crafting them, then you can make them a little bit more tilted in your client's favor. And it's a little bit more work, but I would highly advise you to draft the jury instructions. Make sure you know when all pretrial filings are due, and make sure you know if your jurisdiction requires a request for production at trial of the opposing side. For example, if you are representing the victim of police abuse, if your jurisdiction requires you to serve a request to produce witnesses at trial on the other side, make sure you serve the defense with that. Now, for representing a plaintiff, you're the first person the jury is going to hear about at trial, so start strong. Have one of your best witnesses be the first person you call, and make sure to ask leave of court to treat all police officers as adverse witnesses. That means that you can use leading questions. You don't have to use directed, open-ended, who, what, when, where, why, how questions. You can use cross-examination questions, which gets the points across that you want to get them across. End your case in chief with a bang, whether that is the plaintiff themselves or your best damages witness or your best expert witness. Because studies have shown that many jurors have their mind made up in the first 15 minutes of a case, and that they remember what they are first told and what they are last told. So start with a bang, end with a bang. And this is someone's own personal choice on whether or not they want to ask for a specific dollar amount during closing arguments or not. That can be good and it can be bad. It can be good because you give the jury an idea of what you think the case is worth and what number you think that they should award. It could also be bad because if you ask for $50 million and the jury awards $30 million or $30,000, let's say, then the defense, if you file a petition for attorney's fees, can argue that you were not as successful as you thought. And save your most objectionable arguments for your rebuttal in your closing argument. So the way closings are is the plaintiff goes first, they give their opening close, then the defense close, and then the plaintiff gets a rebuttal. Doing a closing argument is very draining, mentally and physically. So if you save your most objectionable arguments for rebuttal, oftentimes the defense attorney might not be paying attention. And again, the most recent and the last thing that the jury hears is what they're going to remember. So be strong in your rebuttal. And here's something that I've done in the past and I will continue to do in the future, and that is I will trade punitives for costs. I always make a claim for punitive damages, which are damages that would come out of the officer's pockets directly. Most municipalities are barred from paying punitive damages. But like I said earlier, if a plaintiff loses a case, the defense can seek costs. So at trial, I will say, I will not claim punitive damages, or I will not request punitive damages if the defense agrees to not seek costs if a jury finds in favor of the defense. And usually municipalities will do that. And it is something that will shield your client from any financial repercussions if you are not successful at trial. And some tips for representing police officers. As the defense, you do not have the burden of proof, but you need to present your case as if you do. Especially in this climate where people are going to be skeptical of police, you want to present as much evidence that your officers acted properly as you can. Do not let the plaintiff present their case uninterrupted. Now, that's not meaning that you should be an obstructionist or anything like that. But as I say in the next one, ask the judge if for judicial economy, if you can present your officer's testimony when you are supposed to be cross-examining them. So for example, a plaintiff will call the defendant officer during their case in chief, do a cross-examination, and then typically any questioning that you would have of your officer would be limited to what was covered in cross. But ask leave of court to be able to present your testimony through the officer as if it's a direct examination, which would go beyond the cross-examination. And it will really break up the plaintiff's case in chief and will allow you to be able to get your officer's testimony in the record before the plaintiff closes. And think about whether or not you really need to cross-examine every damages witness. If it's mom and she's talking about how much she loves her son, you don't need to depose, you don't need to cross-examine her very much. Have your Rule 50 motion for directed verdict ready. Always file it, always have case law. And I'm gonna have to end there because I am out of time, but a couple of things that I'm going to just briefly touch on. Expect a motion for a new trial or an appeal if you win the case as a plaintiff's attorney. Make sure that you do your Section 1983 litigation, Section 1988 petition for attorney's fees. And for a police officer, if you win your case, caution your client that people may attack the jury verdict in the press and to not take it personally, and discuss with the municipality whether or not it's appropriate to seek costs, because that is a political question that you might not want to get involved in. And if you lose, think about whether or not it is more appropriate to just accept the loss as it is, because remember, bad facts make bad law. So if you take it up on appeal and you lose on appeal, you could create bad law for any future clients that you might have. So I guess that's it. If there's still time for questions, I'm more than happy to do it.
Yeah, Shawn, that was a great presentation. I learned a lot, even working with some law enforcement. I didn't know maybe even 78% of what you're talking about. So I learned a lot today myself. So really quick, I know some folks have to go. We're going to announce the raffle winners really quickly, and then we'll open up the floor for questions for folks who can stay. So we already did a random generator. Chloe was great at getting that going. So the raffle prizes we have for today, there's a professional portfolio. That raffle prize is going to Peyton. There's a Golden Gate University ballpoint pen that's going to Edward. We've got a GGU mug that's going to go to Miranda. And then a School of Law license plate frame that's going to go to Ashley Faulkner. So those are our raffle prizes. Chloe will get in touch with you about getting your address and we'll have that shipped over. And now we'll open the floor up to questions for folks who can stay and those who are available. So any questions that anyone might have? I think Dave's getting, Dave, you got a question there? Yeah, I had a feeling.
Yeah, thanks, Shawn, for your presentation. That was really interesting. Just kind of out of curiosity, when you have one of these cases that is going criminal on the DA is actually prosecuting the cop, and the civil, which is I assume is going to trail behind that. What is the involvement? I know that there's rules. I know in California we have our own rules about what is said in an administrative interviews can't be used in a criminal trial. But how close would you work with the prosecutor?
That's a very interesting question, and it's a very good question because you're right. Sometimes here in Illinois, in Chicago, we have something called COPA, which is the Civilian Office of Police Accountability, which police officers involved in, like, say, shooting cases are required as part of their employment to give a statement to COPA following a police-involved shooting. Obviously, because it is a coerced statement, that statement cannot be shown to the criminal prosecutor and cannot be used in their criminal trial. However, it can be used in a civil trial. And so when I represent plaintiffs in police misconduct cases and the officers being criminally prosecuted, I do work with the criminal prosecutors. I say, hey, any of these family members that you want, we will present them, you let me know, and we will have them there. I currently represent, I don't know how many of you might have heard about this case, but there was a gentleman down in Georgia who was killed by three sheriff's deputies who used a taser device, and all three of them are being criminally prosecuted. I represent the family of the person who was killed. And so we are, our local counsel is working with the Attorney General's office down there to ensure that the officers are going to be retried because the first case was a hung jury. But we are also working the press as well to make sure that the case is kept at the forefront. Now, for police officers, obviously, if you are representing a police officer and there is a civil lawsuit, which I have represented that situation as well, I obviously would file a motion to stay any civil proceeding because I do not. Your client, as a police officer, the statement that they give to any investigative agency, COPA or whatever you have out in California, can't be used against them in a criminal case, but a deposition can. So I don't want my client giving sworn testimony that can be used against him in a criminal case. So if you represent a police officer who is being criminally prosecuted, do not let them testify if you can help it. File a motion to stay, and hopefully the judge will agree and they won't have to testify until the criminal case is over. So that's how I would handle that situation. That's how I have handled the situation, and that's how I'm going to continue to do it in the future. All right. Are there other questions?
Okay, if there's no, oh, there we go. Juan, jump on in there.
Hi, are you able to hear me?
Yeah.
Hey, I was just wondering, so you went to GGU Law. How'd you end up in Chicago?
That's a very good question. How did I go from the greatest city in the world to the city of Chicago? My fiance actually got into medical school at Rush in Chicago. So after I graduated from law school, I studied for the bar as we were driving our stuff cross country, moving to Chicago. And she started medical school. I passed the bar, and I got my master's as I was acting as a volunteer attorney for the City of Chicago Civil Rights Division. And then after I graduated with my master's, a spot opened up and I was hired. So that's how I ended up here.
Wonderful, wonderful. I feel like I'm also on the same boat. My longtime girlfriend is also going to San Francisco. So I'm from LA, but I'm moving to San Francisco. I have another question. So you said if the prosecution wins, they could get payments back for their attorney's fees. What
Yes.
if there's a deal made? Can the prosecution still seek attorney's fees?
So if there's a settlement,
Mhm.
usually the settlement is all inclusive. It's very rare to have a settlement for damages that it does not include attorney's fees. It's not unheard of, but it's very rare that a defense would agree to that. There are situations I was talking about earlier. How do you know if you're going to lose? How to explain it to the officers? If you have a case that you know you're going to lose, look into filing an offer of judgment. What an offer of judgment is, conceding liability, but putting a cap on it.
Okay.
If you let's say you say, we're conceding liability, but we think that your damages are so low that you're not going to get over $15,000. You offer them you send an offer of judgment to the plaintiff for $15,001. And if they refuse it at trial, they have to get a verdict of $15,002. And if they don't, then their attorney's fees are capped at the time that they rejected your offer of judgment. So,
Okay.
yeah, it's a long way of saying settlements usually include attorney's fees, but you can also try to cap it if you think that the plaintiff has a really good case.
Okay. Thank you. Appreciate you answering my questions.
Makes sense, because I wouldn't want someone to keep dragging on litigation, right? Just for something that could have been included in the settlement. So
Exactly. It could be a very minor case, but if they start doing depositions, you
yeah.
can get that $17,000 verdict and 200 grand in attorney's fees.
Yeah, I heard you talk about that one case. So that's pretty crazy. Esra, I think you might be the only one left that hasn't asked a question. Did you have a question, or are you just hanging out?
Just hanging out, listening to everyone else's questions.
Yeah. Okay. Well, Shawn, thank you so much. Some students dwindled off because they had classes, but very interesting presentation. Thank you for joining us today. And then I'll follow up if there's any other additional questions from students, but thank you for your time.
Absolutely. It was a pleasure.
All right. Well,
Thank you.
Thank you. Bye.
Bye.